So I think Aja, you should mute yourself. Aja. So I think Aja.
Huh?
Can you hear me?
Should I call the case, please?
Yes, can we start with Makodi case?
Okay. Which one should I call for, sir?
Makodi's case.
Okay. Resume today, Friday, 3rd March 2023, before his lordship, Honorable Justice S.H. Dangida, suit number NICN/MKD/11/2019, between Farm Dr. Salisu Mohammed and 1. Nasarawa State Specialist Audit Management Board, 2. Chief Medical Director, 3. Jubrin A. Umar. I don't know whether that party is present.
Yes, some are present. I saw the claimant. Yes. Yes, any appearance?
With greatest humility, my Lord.
Yes.
With greatest humility, my Lord.
Thank you.
YYAD, Director of Civil Litigation, Minister of Justice, Lafia.
YYAD.
Yes,
YYAD.
DCL, my Lord.
DCL, okay.
Yes, ma'am. Appear for the defender. I sincerely apologize for the absence.
Okay. Yes. Yes, Mr. What about the counsel for the claimant?
Yes, actually, I'm not surprised that it's not here because he's bereaved. He lost a wife just last, and that baby is not on screen now.
Wow.
Actually lost a wife.
Yes, but I think I saw the claimant.
Okay.
I saw somebody that appears to be the claimant.
Okay, yeah.
On the screen. So I should go ahead and deliver the judgment?
Yes, as the court pleases. The judgment is it does not absence of.
So by a complaint on other accompanying processes dated and filed on 13th of February 2019, the claimant in his statement of facts seeks the following reliefs against the defendant. Number one, a declaration that by the provision of Section 14 of the law establishing the first defendant, only the board of the first defendant is competent to nominate members of the disciplinary committee to hear and determine any case against any senior staff of the first defendant like the claimant. Number two, a declaration that the constitution of the disciplinary committee to hear the case of the claimant by the second defendant, who is a member of the management of the first defendant, that allege the criminal acts and other wrongdoings against the claimant is a violation of the principles of natural justice. Number three, a declaration that there is no lawful disciplinary committee which recommended the termination of the claimant's appointment to the second defendant who purportedly terminated the claimant's appointment. Number four, a declaration that the termination of the claimant is null and void for non-compliance with the principles of natural justice. Number five, a declaration that by virtue of the provision of Section 11 and 14 of the law establishing the first defendant, only the board of the first defendant and not the second defendant is competent to terminate the claimant's appointment. Number six, a declaration that the second defendant's letter dated 5th of December 2013 to the claimant terminating his appointment is ultra vires, null and void, and of no effect whatsoever. Number seven, a declaration that the claimant is still in the service of the first defendant. Number eight, an order of this honorable court will find the disciplinary committee set up by the second defendant to hear and determine the case against the claimant. Number nine, an order setting aside the purported termination of the claimant's appointment and nullifying the second defendant's letter to the claimant in that regard. Number 10, an order compelling the defendant to reinstate and or restore the claimant to his post as the head of pharmacy department of the first defendant with all his right, entitlement, and other faculties of the office. Number 11, an order compelling the defendant to pay to the claimant all the salaries and allowances due to him from the 5th of December 2013 till the day of judgment henceforth. The defendant, upon being served with initiating processes, filed the rejoined statement of defense and other accompanying processes with the leave of court granted on the 5th of November 2019. The claimant thereafter filed a reply to the statement of defense on 29th of November 2019. It is the case of the claimant from his pleadings that he is a civil servant on grade level 15 with the first defendant and was the head of pharmacy until 4th June 2012 when he was suspended. That as an employee of the first defendant, he was working with the Alatu Arab Specialist Hospital. Claimant averred that he was issued a query dated 1st May 2012 and a reminder to the query and later given a suspension letter without pay dated 4th June 2012. That he challenged his suspension among others before the Nasarawa State High Court, while suspension was set aside, and he was as a result of that recalled from the suspension and paid his salaries by the defendant. Claimant further averred that he was surprised to be served with a letter dated 6th June 2013 directing him to answer the query of 31st May 2012, which was the subject matter of the judgment of the Nasarawa State High Court. It is the further averment of the claimant that he immediately answered the said query. However, he was served with an invitation letter to appear before a disciplinary committee on the 2nd of July 2013. Claimant stated that consequent upon the above incident, he took out another writ of summons at the Nasarawa State High Court, challenging the query and invitation letters dated 6th June 2013 and 26th June 2013, respectively. That while the state suit was pending, the defendant again issued him with another query dated 12th November 2013 and a follow-up letter dated 20th November 2013 to appear before a disciplinary committee on allegation of absenteeism. But he stated that he did not appear before the disciplinary committee as his case was already pending before the court. It is the contention of the claimant that it is only the board of the first defendant, subject to the law establishing it, that had the power to appoint, promote, discipline, and terminate his appointment as a senior technical stroke clinical staff. It is the further contention of the claimant that the second defendant is by law not a member of any disciplinary committee, and the board did not nominate members of the disciplinary committee to hear and determine his case. The second defendant has no powers to nominate members of the disciplinary committee to determine his case. Claimant also averred that the second defendant and two other members of the first defendant arrested and forced him to sign and collected his termination letter. Claimant stated that when his appointment was purportedly terminated, the first defendant board was not in place, that the board was reconstituted and inaugurated on the 6th of January 2014. The fact of the defendant case, however, are that while the claimant was working for the first defendant, two complaints of allegation of misconduct and insubordination were written against the claimant. That the claimant was queried and later suspended, but the suspension was quashed by the Nasarawa State High Court. According to the defendant, the judgment of the Nasarawa State High Court did not void or nullify the query earlier given to the claimant dated 31st May 2012. That's why the claimant was served with a reminder to the query dated 6th June 2013 after he was recalled. It is the averment of the defendant that when the claimant was recalled from suspension, he refused to resume duty at Alatu Arab Specialist Hospital or report to the Chairman Medical Advisory Committee, CMAC, on the 30th of May 2013 as directed. That based on the claimant's absenteeism, a complaint letter was received by the second defendant against the claimant, and he was upon that given another query which he ignored to answer. That in furtherance to the above, the defendant served the claimant with another letter dated 20th November 2013 to appear and defend himself before a disciplinary committee, but the claimant also failed to appear before the said committee. The disciplinary committee, after an appraisal of the allegation, contained a letter dated 12th November 2013 and presentations made by other persons submitted its report and recommendation that the claimant be dismissed, but he was terminated instead. According to the defendant, members of the disciplinary committee were nominated and mandated by the first defendant to carry out such assignment, and they did that observing the rules of natural justice. That the first defendant was in place during termination of the appointment of the claimant. It was further advised by the defendant that the action that led to termination of the appointment of the claimant was purely predicated on allegation of absenteeism as contained in the query letter dated 12th November 2013, and the disciplinary committee report and not on any other allegation whatsoever. Trial in this suit commenced on 29th of January 2020 with the claimant testifying as CW1. He had written his two statements on all dated 13th February 2019 and 29th November 2019 respectively as his evidence in chief. CW1 tendered a total of 15 documents as exhibit PSM1 to PSM15. Then accounts the defendant cross-examined the CW1 and the claimant's case was closed and there was no re-examination. Upon close of the claimant's case, the defendant sought to amend their defense, which was refused by the court on the 19th of July 2020. The defendants then opened their defense on the 12th of October 2020, and three witnesses testified on behalf of the defendant. Testifying as DW1 was one Mohammed Okonu. He had written his deposition dated 14th November 2019 and tendered exhibits 1 to 5A and B. DW1 was cross-examined by counsel to the claimant and discharged as there was no re-examination. Testifying on the 17th of November 2020 was one Dr. R.E. Obilom. She had written her statement on all dated 16th November 2020 as her evidence in chief and tendered exhibit 6. DW1 was cross-examined by the claimant's counsel and thereafter discharged in the absence of re-examination. On the same 17th November 2020, one Agbamu testified as CW3. He had written his statement, his evidence in chief, his deposition dated 17th August 2020, and tendered 3 documents as exhibits 7, 8, and 9. DW3 was discharged after cross-examination and re-examination. Counsel for the defendant tendered exhibit 10 from the bar, and the defendants thereafter closed their case, and the case was then adjourned for adoption of final written addresses. I'm going to skip the review of the addresses, please, Mr. DCL. I'm going straight to my opinion. Is having thoroughly looked at the pleadings filed by the parties and their evidence, as well as submissions of the respective counsel, I observed that parties have submitted 4 issues each for determination. But in dealing with the substantive matter, I think the defendant's issue number 3 is more suitable. It states thus, and I quote, whether the claimant has proved his case by preponderance of evidence to be entitled to the reliefs claimed, and I unquote. The defendants have, on a different perspective, raised some preliminary points in their issues 1 and 2, that there is no reasonable cause of action disclosed against the first and third defendant, and that the action is statute bad. It is settled that a cause of action is constituted by the bundle of aggregate of fact which the law will recognize as giving the claimant a substantive right to make the claim against the relief or remedy being sought. See the case of Bello and Attorney General of Oyo State. It was held in Ilo and Farehimi number 2 that a cause of action is any act on the part of the defendant which gives the plaintiff his cause of complaint. Therefore, the defendant's wrongful act and the consequential damage to the claimant are the 2 factors that must coexist to consider a cause of action before the court. It does not take account of whether the cause of action will succeed or fail. A cause of action is valid irrespective of the strength or weakness of the claimant's case. See the case of Exebe and Agolo. I should say here that the contention of the counsel for the defendant that the claimant has not a cause of action against the first and third defendant will be determined by examining the argument made in the claimant's pleadings. Therefore, I will only confine myself to those arguments in the pleadings to assess whether there is a reasonable cause of action or not. It can be observed that the query issued to the claimant which led to his termination and the termination letter itself were all issued and signed by the third defendant, who also served as the member of the disciplinary committee that recommended the termination of the claimant. It's clearly further stated in the claimant's pleadings that his appointment is governed and regulated by the law establishing the first defendant. It was also about that it is only the first defendant, subject to the law establishing it, that has the power to appoint, promote, and or terminate the claimant. To the further affirmation of the claimant that his termination was not sanctioned by the first defendant. I need to state here that the above stated facts averred by the claimant in statement of fact entitled the claimant to hearing on merit of his case, hence establishing a valid cause of action against the first and third defendants. Following from the above, therefore, I do not agree with the learned counsel for the defendant that there's no valid cause of action against the first and third defendants. On the issue of statute bar, the defendant have relied on Section 2A of the Public Officer Protection Law to submit that the claimant's case is stale, same having been initiated beyond a period of 3 months as provided by the law. But for the defendant, there had been his case pending before the National State High Court before his termination, and he amended his plea to include the issue of the termination. See paragraphs 37 to 39 of the statement of fact. It can be observed from the above that right from the time that the termination of the claimant arose, he challenged same by amending his plea in his earlier suit, which though was struck out, and by so amending, the instance case of the claimant cannot be said to be cut off by the provisions of Public Officers Protection Law, and I so hold. In the light of the above, I not subscribe to the view that the claimant's case is statute barred. See the case of Syfax and MIG4. Claimant has also argued that Exhibit 4B should be expunged because it was signed by the third defendant, his offense Section 3, sub 3 of the Evidence Act. My view on that is simply that Section 3, sub 3 of the Evidence Act is not applicable here. Section 3, sub 3 only talks about document made by an interested party pending or in anticipation of proceedings. Exhibit 4B, which is the time book, cannot be said to have been made pending or in anticipation of any proceedings by the third defendant, and I so hold. Turning to a substantive case, claimant has asked for some declarations, among others, that the Constitutional Disciplinary Committee to hear his case by the second defendant is a violation of the principles of natural justice, that there's no lawful disciplinary committee which recommended his termination, that his termination is null and void for non-compliance with the principles of natural justice, that is only the body of the first defendant and not the second defendant that's competent to terminate his appointment. Claimant has therefore asked for an order setting aside the purported termination and nullifying same, and has also asked for an order of reinstatement and payment of his salaries and allowances. Claimant's claims are premised on the fact that he was issued a query dated 31st May 2012 and a reminder to the query, and later given a suspension letter without pay. That he challenged his suspension, among others, before the National State High Court, while suspension was set aside, and he was then recalled from the suspension and paid his salaries. That after the claimant was recalled, he was served a letter dated 6th of June 2013, directing him to answer the query of 31st May 2012, and later invited to appear before a disciplinary committee on the 2nd of July 2013. Although the claimant answered the query and appeared before the disciplinary committee, but he took out the writ of summons at the National State High Court, challenging the query and the invitation letters. That while the sales suit was pending, the defendant again issued him another query dated 12 November 2013 and a letter dated 20 November 2013 to appear before a disciplinary committee on allegation of absenteeism. But the claimant did not answer the query nor appear before the disciplinary committee, contending that his case was already pending before the court. The defendant, however, argued that when the claimant was recalled from suspension, he refused to resume duty at Lato Arab Specialist Hospital or report to the CIMAC on the 30th of December or 30th of May 2013 as directed. That is, it was based on the claimant's absenteeism that he was given another query dated 12 November 2013 and invited to a disciplinary committee, which he ignored to answer and appear respectively. I wish to observe here that the first suit filed by the claimant before the National State High Court was in respect of his suspension, which was quashed. And after he was recalled from the suspension, he was issued a letter to answer the query of 31st May 2012, which he answered and appeared before the disciplinary committee. But he filed the second suit, challenging the query and the disciplinary committee. And it was while the second suit was pending that the defendant issued the claimant another query on absenteeism, which finally led to his termination. So the termination of the claimant was on absenteeism and not on any other thing. Based on the above, therefore, I do not believe that the second suit filed by the claimant has anything to do with his termination then. That is why the claimant averred that after his termination, he amended his pleading to incorporate the issue of his termination. Therefore, the contention of the claimant that he not answer the query of 12 November 2013 and appear before the disciplinary committee by a letter dated 20 November 2013 because he had a pending case before the Inndustrial State High Court is misconceived. It must be stressed that an employer has inherent powers to discipline its employee according to contract of employment, while the conduct of the employee constitutes a misconduct. See the case of Zainabu and Baron University, Kano. In the case of Arinze and First Bank of Nigeria PLC, the Supreme Court held that in both statutory and private employment, the employer can dismiss an employee of gross misconduct, bordering on crime, and it's not a requirement that he must first be tried in the court of law. The Supreme Court further held that in case of misconduct bordering on crime, all that is required of the employer before the summary dismissal is to give him fair hearing by confronting him with the allegations against him and give him the opportunity to defend himself. The law is also that where an employer dismissed or terminated the appointment of an employee on grounds of misconduct, all that the employer needs to establish to justify his action is to show that the allegation was disclosed to the employee, that he was given a fair hearing. That is to say that the rules of natural justice were not breached and the disciplinary panel followed laid down procedure, if any. See the case of University of Calabar and ASEAN. I need to point out that even if the case of the claimant that was pending at the Inndustrial State High Court had to do with his case of absenteeism, which was not the case, all he would have done was to answer the query of 12 November 2013 and now appear before the disciplinary committee and formally inform them that he had a pending case on the issue to be deliberated upon by the disciplinary committee and choose to stop there. But by his attitude of ignoring to answer the query and not appear before the disciplinary committee, will not be taken seriously afterwards that he had any issue either with the constitution or composition of the committee or that the matter was sub judice. I need to further add that the process of fair hearing is two-edged sword and it cuts both sides. The right of the two parties must be balanced and one cannot be sacrificed to the other without perverting justice. All that's needed is that an enabling environment has to be created and maintained for parties to ventilate their grievances, either in proceeding against or defending their case, and where any party refuses, neglects, or fails to take advantage of the fair hearing environment so created, he that is in default cannot be heard to raise any accusation of his denial of his fair hearing, of his right to fair hearing. He would have himself to blame. See the case of Inoga and Inoga, Kwara Ministry of Health and Electrical Enterprises Limited. Claimant has contended that it is only the board of the hospital that can appoint a disciplinary committee, and since the board was not in place, it could not have nominated members of the disciplinary committee. It becomes necessary to state here that the law places a burden on a person who makes any assertion to prove same, and the claimant's counsel in its submission argued that since the defendant had denied that there was no board, then the burden is on the defendant to prove that assertion. However, Section 1681 of the Evidence Act says that when any judicial or official act is shown to have been done in a manner substantially irregular, it is presumed that the formal requisite for its validity were complied with. And subsection 2 of the said section says that when it is shown that any person acted in a public capacity, it is presumed that he had been duly appointed and was entitled to so act. It is my view from the above that the law presumes that there is a board of the first defendant in place and that the third defendant and the members of the disciplinary committee acting in their capacity, in their public capacity, are presumed to have been duly appointed to so act until contrary is proved. And the burden to prove the contrary is on the person who asserts that there was no board in place. See the case of SHMO and Abul. In the case of OG and INEC, it was held that there is a presumption that election took place everywhere on the election day. The claimant about that the board of the first defendant was not in place at the time of his termination, as it was dissolved by the executive governor of Nasarawa State and reconstituted and inaugurated on the 6th of January 2014. However, in the entire pleadings and evidence of the claimant, I've not found enough evidence capable of proving the fact that the board was dissolved and reconstituted by the governor. Claimant in his evidence under cross-examination stated that, and I quote, "The resolution of the first defendant at its reconstitution was announced over the radio, but I do not have any document to that effect," unquote. I find that the claimant bears the burden which he has not been able to discharge. Accordingly, the relief sought by the claimant to declare that there is no lawful disciplinary committee which recommended his termination is declined. Coming to the issue of absenteeism, the defendant tendered exhibit 4A. It is a complaint written against the claimant that ever since he was recalled from suspension on 28th of May 2013, he had not been going to work. They also tendered exhibit 4B, which is the time book for Lato Arab Specialist Hospital. DW1 said under cross-examination that the absenteeism problem is one between the claimant and the defendant, which was not resolved. That the claimant was not directed to report to him, but never reported to the CIMAC either. That he received calls from the CIMAC asking why the claimant refused to report to duty. DW2 CIMAC also testified under cross-examination that the claimant did not report to her upon his recall and that she would have been informed if he had reported. She also said that the claimant never came to work, and his head of department confirmed to her that the claimant had not been going to work, but he went to work on the 23rd and 24th September 2013, according to exhibit 4B. DW3 also said in his testimony under cross-examination that they found the claimant guilty of absenteeism from 28th May 2013 to 5th of December 2013. He said that there was evidence that between 28th 5 2013 and 5th November 2013, the claimant went to work on some days. That he went to work on 24th 9 2013, and his name also appeared somewhere in the time book, exhibit 4. The above is the evidence of the defendant with regards to the absenteeism of the claimant, but the claimant who bear the burden to prove his case has not been able to proffer contrary evidence about his absenteeism. It's clear that the claimant was given the opportunity to answer the query given to him and appear before the disciplinary committee on the issue of his absenteeism, but he failed to seize the opportunity to do that. It was noted earlier that where a person is given opportunity to be heard and the charge of complaint against him made available to him, he cannot complain of breach of fair hearing principle. See the case of Arabic here and LMC. On the allegation of breach of the principles of natural justice, it is clear that the complaint that led to the query given to the claimant was written by DW1. And as a result of that, the third defendant issued a query to the claimant on behalf of the medical director, the Lato Arab Hospital, and participated in the disciplinary committee and signed the claimant's termination letter. The only thing I can say is that the third defendant was a director, admin, and supplies of the claimant's place of work. But I cannot find any evidence that the third defendant had an issue with the claimant beside his official schedules, which he was assigned to undertake. I cannot find evidence making the third defendant as an accuser and a judge over the claimant's case. The mere fact that the third defendant signed the query on behalf of the medical director and participated in the disciplinary committee and signed the claimant's termination letter without more does not mean that the third defendant has any interest in the matter against the claimant. I therefore find that the allegation of breach of the principles of natural justice by the third defendant against the claimant is not substantiated. Considering the above, I find on the whole that the claimant has not been able to prove his case to be entitled to the reliefs sought. The issue for determination chosen above is resolved against the claimant. His case therefore fails and is accordingly dismissed. However, I believe that since the claimant was only terminated, then he will be entitled to his pension and gratuity in accordance with the law of the Inndustrial state and the law establishing the first defendant, having him worked from 1991 to 2013. Mr. Ede. Mr. Ede, you are muted.
Sorry, my lord, can you hear me, my lord?
I can hear you
Hello,
now.
my-
Yes. I can hear you.
We are actually grateful for the judgment just delivered, and we pray that Almighty Allah will take you to greater height by the special grace of God.
Thank you.
Thank you, and we wish you very good and sound health in the
You should go.
hereafter.
You should go and pay him.
Thank you.
You should go and pay him his pension gratuity.
My lord,
Hmm?
I want to assure you, we have no problem in paying him his entitlement. We are so
Okay, thank you.
magnanimous, like I told you, man. Yes, man. Thank you, man. I wish you the best.
Thank
man.
you. Thank you.
Yes, sir. Yes, sir. May I humbly take my leave?
You can go. Thank you. Adia,
Yes, my lord.
the 4/1/2019.
Okay, my lord. Suit number NICS/LSR 41/2019 between Mr. Adebayo Adesina and Veritas Grand Pensions Limited. But it's like the payment is online.
Payments online.
I don't know. No, the claimant is absent, my lord.
Claimant is present.
My lord is absent. He's absent. The claimant is
Okay.
absent.
So the party is absent.
Yes, my lord.
My lord.
Okay. Yes, Mr. Yusuf K.
Maybe your lordship, I am praying with you, my lord.
Yeah,
My lord,
alone.
my lord, I appeal with my learned friend, ZK Amida.
Eh?
My lord, ZK Amida, AMIDA.
Okay, Amida.
Yes, my lord. My lord, our appearance is for the claimant.
Yes, and Folashades.
Yes. May it please my lord, Folashade Ali. Appearing
Yes.
with me is my learned colleague, Umar Saka. Our appearance is for the defendant.
Okay, Saka.
Yes, my lord. My lord, the suit is for judgment.
Okay. So this is my judgment. The claimant commenced this suit by way of complaint and other accompanying processes filed on the 1st of February 2019, wherein the claimant in his statement of fact asked for the following reliefs against the defendant. Number one, a declaration that the detention of the claimant's accrued salaries for the months of November and December 2018, 2 weeks leave and encashment and severance package by the defendant is wrongful. Number two, a declaration that the continuous detention of the claimant's accrued salaries, leave, pay, and severance package by the defendant since November 2018 amounts to unfair labor practice. Number three, a declaration that the surrounding circumstances leading to the resignation of the claimant from the service of the defendant amount to constructive dismissal. Number four, an order of the court compelling the defendant to immediately pay the claimant the following sums: 6,805,740 naira being the claimant's salaries for November and December 2018. 1,705,260 naira being the outstanding 2 weeks leave encashment due to the claimant. 6,895,740 naira only been the claimant's 2 months salaries as content merit for severance package due to the claimant in accordance with the clause 6.4 of his contract of employment. Compound interest of 21% per annum on the sale sums from the 1st of January 2019 until said debts are liquidated. 1 million naira being damaged for wrongful retention of the claimant's salaries, leave, encashment, and severance package. 1 million naira being exemplary damaged for unfair labor practice meted to the claimant by the defendant. 90 million naira being damaged for the constructive dismissal of the claimant from the service of the defendant. 1 million naira being the cost of this suit. The defendant, in reaction to the claimant's suit, entered appearance and filed a statement of defense to a counterclaim by an order of court granted on the 10th of April 2019. Meanwhile, the claimant filed a reply to the defendant's statement of defense and defense to the counterclaim on the 8th of April 2019, and the defendant also filed a reply to the defendants to the defense to the counterclaim. The defendant relieves in the counterclaim against the claimant as follows. Number 1, a declaration that the collection of the sum of 6 million naira from the defendant's contractor and 5,858,821 naira from the dependent company as leave allowance amounted to unjust enrichment at the expense of the defendant. Number 2, an order directing the claimant to refund the sum of 5,558,821 naira, the monies collected by the defendant as leave allowance, which is not entitled to. Number 3, an order of the court directing the claimant to pay over the sum of 5,888,821 naira and 6 million naira as restitution to the defendant, being the sum received by the claimant as unjust enrichment. Number D, prejudgment interest at the rate of 10% from when the sale sums were received by the claimant and 10% from the date of the judgment until when the claimant finally pays over the sum of 6 million naira. Cost of this action assessed as 2.2 million naira payable on a cost and indemnity basis. It is the claimant's case that from his pleadings and testimony, it's the claimant's case from his pleadings and testimony that he's a former employee and the erstwhile managing director of the defendant, but the defendant made it impossible for him to function and carry out his duties as the managing director of the defendant company. Hence, he was constrained to resign his appointment as the managing director of the defendant by tendering a resignation letter in October 2018, which was to take effect from 1st December 2018. Claimant avowed that while in the employment of the defendant, he discharged his duties as the managing director without any blemish, as he was never issued any query nor given any warning. It was avowed by the claimant that his resignation from the employment of the defendant company was born out of the deliberate attempt by the defendant board to frustrate and force him out of office as the MD of the company. The defendant also tried to implicate the claimant in the Africa Infra Plus Fund, AIPF transaction, which was carried out in good faith. Claimant stated that his resignation was accepted by the defendant with immediate effect on the 8th of November 2018, as against 31st December 2018, as stated in his letter of resignation. That the defendant, having waived the notice period given by the claimant, is entitled to salaries for the months of November and December 2018, including other entitlements as stated in his reliefs. The defendant's case, however, is that the claimant's allegation regarding constructive dismissal is untrue and erroneous. The defendant further avowed that the claimant's terms of employment was never altered nor changed to his disadvantage throughout the period of his employment with the defendant. It was further avowed that the claimant maintained the authority to run the defendant on a day-to-day basis upon his voluntary resignation, but only that the defendant board of directors intervened in the AIPF transaction, whose intervention became necessary to protect the defendant's interest. According to the defendant, the claimant did not meet his key performance indicators, KPIs, to grow the business of the defendant as contracted. that the claimant did not perform to the expectation of the board, to which he admitted he would do better, that he had carried on with the investment decision in the AIPF transaction without the approval of the board of the defendant company, notwithstanding the opposition of the transaction by the head of investment of the defendant, who had previously advised against proceeding with the same on the ground that due process was not followed in terms of obtaining the necessary approvals from the board. According to the defendant, the claimant knows that the transaction would have an adverse consequence on the capital adequacy of the defendant. The defendant said that the claimant has not been acting in the best interest of the defendant as against his statutory and contractual duty to maintain the confidence of the board at all times. For the further amendment of the defendant, that resignation of the claimant was in breach of the terms and conditions of employment, which required the claimant to give 3 months' notice in lieu of payment. To the defendant, the claimant had been demanding and receiving kickbacks from third-party contractors who rendered services to the defendant, and thereby resulting in inflation of contracts. Trial commenced on 28th of October 2021, while the claimant testified by adopting his true statement on oath. Dated 1st February 2019 and 8th April 2019 as his evidence in chief respectively. Claimant also tendered exhibits C1 to C29A and B as his documents to rely upon in proving his case. Claimant was thereafter cross-examined by the counsel for the defendant and decided that there was no re-examination, and the case of the claimant was then closed. The defendant opened his case by calling DW1, who adopted a witness statement on oath dated 8 March 2019 and tendered exhibit VGP1A to VGP14A to E. DW1 was thereafter cross-examined by the Land Council, the claimant, re-examined and discharged. Then DW2 was also called. He adopted his statement on oath dated 25th of May 2022 and tendered exhibit VGP15 and to VGP18. DW2 was cross-examined and decided as there was no re-examination. The defendant also called DW3, Shogun Ogundipe. He adopted his witness testimony on oath dated 8 March 2019 and tendered exhibit VGP19A and B. DW3 was discharged after being cross-examined as there was no re-examination. The case of the defendant was then closed and the matter was adjourned for adoption of final written addresses. The defendant's final written addresses dated 3rd October 2022 was filed on the 12th of October 2022, wherein 8 issues for determination were submitted to it. I will skip the 8 issues, please. Counsel submitted on issues 1 and 2 that the claimant's resignation letter exhibit C10 is in breach of clause 6.1 of the contract of employment exhibit C2B because it falls short of the length of notice that is required for the successful termination of the employment of contract between the parties. That the claimant shall be directed to pay over to the defendant 3 months' salary in lieu of notice. Counsel further submitted that the law is tried and has been firmly established that the costs are bound by the agreement of parties. Counsel referred to the case of Lamia and data processing maintenance services. It was also submitted that the claimant is not entitled to the sum of 6 million naira, nor any sum whatsoever been his acclaimed salary for the month of November and December 2018. Counsel argued on issue 3 that sequel to clause 4.4 of the contract of employment, the claimant is not entitled to the sum of 1.7 million naira, nor any sum whatsoever been the claimant's claim for the outstanding 2 weeks leave encashment. Referring to the case of Olatunde and OAU and another, that the contract of employment does not require any external aid for its interpretation. That the claimant is not entitled to any leave allowance. That by the provisions of clause 4.4 of exhibit 2B, the claimant will only be entitled to annual leave after 12 months of continuous service with the defendant, but it only served from 15th January 2018 to 24th October 2018. It was argued on issue 4 that clause 6.4 of the contract of employment does not apply to the facts and circumstances of this case. That the said clause would have been applicable in the circumstances where the claimant's employment is determined by the defendant. Such in the case of Angwa Cement and Anyafu. Counsel submitted that the claimant is not entitled to the sum of 6 million naira as severance package, as he has not led any evidence in support of his claim or refer the court to any provision in the defendant's policy that entitles him to the said sum. Counsel's submission on issue 5 and 6 is that the claimant has failed to establish a case of constructive dismissal against the defendant. That the constructive dismissal is a question of facts. That the claimant ought to lead evidence to show that the terms and conditions of his employment were materially altered to his disadvantage by the defendant's conduct. Such in the case of Western Excavation, ECC Limited, and Sharp. Counsel also refers to the minutes of 14th special meeting of the defendant's board of directors held on the 2nd of October 2018. He submitted that allegation of constructive dismissal is an afterthought, and the claimant ought to have raised the issue at the earliest opportunity. Counsel referred to Exhibit C21, where the claimant gave his reason for resignation but not raised the issue of constructive dismissal. Counsel submission on issue 7 and 8 is that the claimant is not entitled to damage for unfair labor practice, but the defendant is entitled to the relief sought in his counterclaim, referring to the case of Olatunji and Unity Bank PLC. Claimant's final written addresses dated 29 September 2022 and filed on 30 September 2022 contains 4 issues for determination to it. We'll skip them. It is submitted on issue 4 that the argument of the defendant that the notice given by the claimant falls short of the mandatory requirement of 3 months is belated. That following the service of the claimant's resignation letter on the defendant via Exhibit C22 accepts the resignation of the claimant and asks that same take immediate effect, thereby asking the claimant not to work since 31st of December 2018. Claimant stated that the defendant, who is the author and custodian of Exhibit C, 2A, and B, and with full knowledge of its content, never raised any issue with the claimant as regards the notice period the claimant has given in Exhibit C21A. Instead, the defendant decided to expressly waive the need for notice and directed the claimant's resignation that the claimant's resignation should take immediate effect. It was also submitted that the defendant, having accepted the resignation and by directing the claimant's resignation, that the claimant's resignation should take immediate effect, has waived its right to the contractual terms between the parties. The defendant act of acceptance speaks to this effect. It is tried law that a party cannot approbate or reprobate at the same time. Such in the case of the Canon Investment Limited and SEC. Counsel submitted that when the claimant tendered his resignation, the defendant accepted same and never complained about the notice period not being sufficient in accordance with Exhibit C2A and B. Rather, the defendant responded that the claimant's resignation should take immediate effect. Another counsel submission on issue showed that the facts and circumstances surrounding the claimant's resignation can lead to constructive dismissal. Such in the case of Ms. Ebere Okoji and Standard Alliance Life Assurance Company Limited, where it was held that the resignation of employee could be triggered by a single event or series of incidents which happened shortly before the resignation being fundamentally laced with involuntariness and thus entitled the aggrieved employee to approach the court for relief after existing the employment. Counsel contended that the words used by the claimant and the surrounding circumstances irresistibly point to the fact that the claimant's resignation wasn't voluntary, but rather constrained to resign in light of the things he was passing through in the hands of the defendant, especially when asked to admit to Penko on an error he never committed. Then counsel argued on issue 3 that the claimant has proved his case and is entitled to the reliefs sought. That the magnitude of the wrong done to the claimant by the defendant makes the claimant to be deserving of the damages sought against the defendant. Counsel contended on issue 4 that the defendant has failed to prove his counterclaim, that the counterclaimant has recovered his money from the appropriate quarters and has only included the claimant in the petition to humiliate and victimize the claimant, Counsel finally urged the court to grant the reliefs of the claimant and dismiss the counterclaim of the defendant. Reply on points of law. Counsel to the defendant filed a reply on points of law on the 13th of October 2022. It was argued in response to the claimant's submission in his final written address that acceptance of the claimant's resignation by the defendant did not amount to a waiver of the claimant's contractual obligation under Exhibit C2. That acceptance of the claimant's resignation by the defendant did not cure the defect or anomalies in the resignation letter. Setting the case of Liade and Panalpina World Transport Nigeria Limited. Counsel further argued that the defendant was obligated to receive the claimant's letter, and the defendant timelessly joined issue with the claimant regarding the defective nature of the claimant's notice of resignation. Counsel noted that the claimant gave instance of constructive dismissal but neglected to cite any authority in support of his submission. Counsel argued that the claimant unilaterally negotiated and entered the Africa Infra Plus Fund transaction without the consent of the defendant's board of directors. It was submitted that the appropriate time to challenge the admissibility of a document is when the document is being tendered. That exhibit VG P12 was submitted in evidence without any objection. The claimant cannot challenge the admissibility of such document at this stage of the proceedings. Counsel finally contended that the doctrine of waiver does not apply to the facts and circumstances of this case, that the claimant was not allowed to proceed on leave based on compassionate ground of ill health. So my opinion, from my calm look at all the processes filed by the parties and the respective submissions, the claimant's main case is that as the erstwhile managing director of the defendant made it impossible for him to function and carry out his duties. Hence, he was constrained to resign his appointment as the MD of the defendant. The defendant, on the other hand, stated that the claimant's resignation was voluntary and not a constructive dismissal. Claimant, on behalf of the defendant, in arguing his case, submitted eight issues for determination, while the claimant submitted 4 issues in arguing his case, which to me are more suitable and direct. The issues are those, and I quote: number 1, whether the defendant can allege the breach of contract in the face of the glaring waiver of his right. Number 2, whether the claimant has established a case of a constructive dismissal against the defendant. Number 3, whether the claimant has proved his case to entitle him to the reliefs sought. Number 4, whether the defendant has proved its counterclaim. It was the contention of the claimant that when he tendered his resignation letter, which was to take effect on the 1st of January 2019, the defendant sent Exhibit C22 accepting the resignation, but with effect from 8th November 2018, thereby waiving its right to the contractual terms between the parties. The defendant argued that the notice given by the claimant falls short of the length of notice that is required for the rightful termination of the employment of contract between the parties. That the claimant should be directed to pay over to the defendant 3 months' salary in lieu of notice. Defendant cites clause 6.1 of the contract of employment exhibit C2B, which says that the contract may be terminated by either party by giving 3 months' notice or 3 months' salary, basic salary in lieu of notice. Inasmuch as it is stressed that the courts are bound by the agreement of the parties, but the defendant needs to ask the court to declare the claimant's resignation wrongful to entitle the defendant to the 3 months' notice in lieu of 3 months' salary in lieu of notice. I've not seen the defendant do that in his counterclaim, but what I can only see that what I only can see is the request in that regard from the defendant for the first time in his final written address, which cannot take the place of evidence no matter how brilliant it appears. I will therefore decline to make a declaration or pronouncement on whether the notice given by the claimant falls short of the requirement of clause 6.1 of Exhibit C2B, because the claimant did not ask for that in his counterclaim. In law, it is not right for courts of law to award a relief not sought, as law courts are neither charitable organization nor Father Christmas. See the case of Jim Jaja and COP River State. I need to say that a notice of resignation of an appointment becomes effective and valid the moment it is received by the personal authority to whom it is addressed. This is because there's absolute power to resign and no discretion to refuse or to accept. And it's not necessary for the person to whom the notice of resignation is addressed to reply that the resignation is accepted. See the case of Yusufu and Governor of Edo State. Coming to the issue of constructive dismissal, it is contended by the claimant that the defendant did not prove the allegation that the claimant agreed to enter AIPF transaction for his own personal gains, and that the approval limit of 1.5 billion naira of the said transaction was subject to the board approval. Claimant further contended that the action of the defendant that led to his involuntary resignation began when the AIPF requested the defendant to pay his first tranche of the investment. But despite the queries raised which were resolved, an instruction from the claimant to the head of the investment to deposit the first tranche of the money, the payment was still not made because the head of the investment was taking instruction from the chairman of the board of directors. Claimant also alleged that the AIPF petitioned PENCOM as a result of the defendant's failure to proceed with the AIPF transaction, while the chairman of the board of directors directed the claimant to respond to the petition and admit personal and corporate liability. Claimant referred to Exhibit C18 dated 22nd of October 2018. That when the claimant in his response to the petition did not do the bidding of the claimant or the chairman of the board of directors, the chairman made weighty allegations against the claimant to PENCOM. According to the claimant, it is the above acts of the defendant that frustrated him out of office, where he was constrained to resign his appointment. This court has dealt with the concept of constructive dismissal in the number of cases. For instance, see Ms. Ebere Okweji and Standard Alliance Life Assurance Company Limited, Mr. Patrick Obiora and United Bank for Africa, Mrs. Angela Atanda and Abbey Building Society, and Joseph Okafo and Nigerian Aviation Handling Company, PLC. In Ms. Ebere Okoji and Standard Alliance Life Assurance Company Limited, Supra, it was held thus, and I quote, globally, and in labor/employment law, constructive dismissal, also referred to as constructive discharge, occurs when an employee resigns because he or her employee's behavior has become intolerable or heinous, or made life difficult that the employee has no choice but to resign. Given that the resignation was not truly voluntary, it's in effect a termination. In an alternative sense, constructive dismissal or constructive discharge is a situation where an employer creates such working conditions, also changes the terms of employment that the affected employee has little or no choice but to resign. Thus, where an employer makes life extremely difficult for an employee to attempt to have the employee resign, rather than outright firing the employer is trying to create a constructive discharge. The exact legal consequences differ from country to country, but generally a constructive dismissal leads to the employee's obligations ending and the employee acquiring the right to seek legal compensation against the employer. The employee may resign over a single serious incident or over a pattern of incidents. Generally, the employee must have resigned soon after the incident. See generally Western Excavation and Sharp. Unquote. For the claimant to succeed in a case for constructive dismissal, he must bear the burden to show that he has resigned soon after the incident he's complaining about, as suggested in the case of Ms. Ebere Okoji and Standard Alliance Life Assurance Company. He must also prove, as stated in the case of Western Excavations and Sharp, that there is a repudiatory breach, actual or anticipatory, on the part of the employer, which must be sufficiently serious to justify the employee resigning. The employee must resign in response to the breach, and the employee must not delay too long in acting on the breach. To the contention of the claimant, as stated earlier, that it was the defendant weighty allegations against him made on 24th of October 2018 to PENCOM that frustrated him out of office, where he was constrained to resign. That he also stated in his resignation letter, Exhibit C21A, on the same 24th October 2018, that he was constrained to resign as a managing director stroke CEO. I need to observe that the letter carrying the alleged weighty allegations Exhibit C20 is dated the same 24th October 2018 and addressed to PENCOM, but was received on 25th 10 2018. That is a day after the resignation of the claimant. I need to further observe that the claimant did not actually detail the defendant his reasons for the resignation, but he only stated thus, and I quote, "In the light of this, I'm constrained to resign as the managing director to CEO with effect from 1st January 2019, with the hope that the rest of this year up to 31st December 2018 will serve as a transition period in which I will be able to hand over the reins of the company to a successor duly appointed by the board of directors," unquote. However, in Exhibit C21B, the claimant also sent a letter of his resignation dated 24th October 2018 to PENCOM and attached his reasons for his constrained resignation. It was also stated in the report of on the meeting between PENCOM and the board of directors, Exhibit VGPH at page 3, that the claimant did not share his reasons for the defendant, despite being instructed by the defendant to avail the board the copy of the attachment containing the reasons of his resignation for record purposes. One of the things that is of concern to me is that why should the claimant not share his reasons for his constrained resignation with the defendant if he actually wanted the defendant to take him seriously and believed that he was processed out of office by the defendant as a result of those reasons? Another cause of concern is also that the claimant appears to be more interested and bothered about his 2 months salary of November and December 2018 instead of the claim for constructive dismissal. This is evidence in Exhibit C23, where the claimant, after his resignation, asked from the defendant his 2 months salary, outstanding leave allowance, and severance package. Exhibit C25, which is the claimant's solicitor's letter, has further corroborated this fact when it said that the defendant would be taken to court by the claimant for constructive dismissal, among others, if the defendant refused within 7 days to meet the claimant's demand of payment of salaries, outstanding 2 weeks leave, pay, and severance package. So this appears that the claimant would not have sued for constructive dismissal if he were paid the money he demanded from the defendant. I should say that the claimant cannot eat his cake and have it. It was stated by the defendant in paragraph 11 of his statement of defense that despite that any investment is within the approval limits of MIC, the nature of the risk inherent in the sanction may require that the investment be discussed and examined by the board before its condemnation, given that the defendant operates between a low to moderate risk policy. As such, any higher risk transaction, irrespective of whether it is within the approval limit, must be before the board. The defendant was also about that the AIPF transaction was an investment in the private equity fund, which is considered a very risky asset class. Hence, the defendant policy not to invest more than 5% of the value of pension asset to any issuer. That the claimant knows that the defendant would not commit such staggering amount into one transaction, given the high risk involved in the event of an adverse occurrence with the transaction. From the facts and circumstances of this case, I'm not persuaded that the claimant resigned his appointment because of the defendant's behavior, which has become intolerable, or made life difficult, that the defendant had no option than to resign. I agree that the intervention of the board of the defendant did not affect any of the terms and conditions of the claimant's employment, and did not tend to demote him or make the working condition less favorable to him. I also agree with the defendant that his intervention was only in relation to the AIPF transaction, which will serve the interest of the defendant. Claimant under cross-examination said that the board had oversight function on him on how the defendant funds are to be invested, and the board shall always have confidence in his capacity and performance. He also stated under cross-examination that the head of investment did not disburse the funds of the investment because he was not comfortable with the investment, and he had issue with the approval limit. I think this goes to show that the defendant is within its right to do as it did to the claimant in the AIPF transaction, which does not in any way mean frustrating the claimant out of his employment. Therefore, leaves 3 and 4, that the circumstances leading to the claimant's resignation amounted to constructive dismissal, and 90 million naira damages for the constructive dismissal failed and are accordingly dismissed. On the claimant's claim for accrued salaries for the months of November and December 2018, 2 weeks leave encashment, and severance package by the defendant. Since I have noted earlier that there is absolute power to resign and no discretion to accept or reject the resignation, then the defendant acceptance of the claimant's resignation becomes inconsequential. The claimant, having put in his resignation to take effect on the 1st of January 2019, is therefore entitled to his salary of November and December 2018, as he had chosen to stay with the defendant up to the 31st of December 2018, according to his resignation letter. The argument of the defendant that the claimant was under investigation on some allegations and he would not be paid until he was cleared of those allegations is of no moment. The petition exhibit VGP 12 issued to the EFCC against the claimant was a document made pending proceedings, hence offense the provision of Section 83 of the Evidence Act. The argument postulated by the defendant that the claimant cannot challenge the admissibility of VGP 12 at this state of proceedings because it was admitted without any objection is misconceived. In any event, it was stated by DW1 that the claimant was not indicted by the EFCC when exhibit VGP 12 was sent to it. For the outstanding leave encashment, I think since the claimant was earlier given the leave allowance, which should be given the outstanding allowance having him work with the defendant for 1 year, as provided in clause 4.4 of the Human Resources Manual. For the severance package, it's provided in clause 6.4 of Exhibit 2B, thus, and I quote, a severance package may be payable to the employee if his termination is not connected to fraud or negligence. Cost to FUG out clause 6.2 A to D. The package will be in accordance with existing policy on severance on court. It was the argument of the defendant that the claimant did not refer the court to the company's existing policy that entitled him to the sum claimed. I agree that it is a special claim that must be specifically proved and strictly pleaded. Having the claimant not referred this court to the exact document conferring the entitlement, that relief fails and is accordingly dismissed. For the counterclaim, I hold the view that the defendant has not been able to prove the criminal allegation that the claimant collected the sum of 6 million naira from the defendant contractor. As I've earlier stated, the evidence of DW1 admitting under cross-examination that the investigation done by the EFC did not indict the claimant is apt here. I also find no evidence for the claim of 5,858,821 naira against the claimant as unjust enrichment at the expense of the defendant. I therefore find no merit in the relief sought in the counterclaim. It is therefore declined and accordingly dismissed. All said the claimant's case succeeded in part, and for the avoidance of doubt, I hereby make the following declaration and orders as follows. Number one, a declaration that the detention of the claimant's accrued salaries for the months of November and December 2018 and 2 weeks leave encashment by the defendant is wrongful. An order of court that the defendant shall immediately pay the claimant the sum of 6,895,740 naira, being the claimant's salaries for November and December 2018. The defendant shall also pay the claimant the sum of 1,705,260 naira, being the outstanding 2 weeks leave encashment due to the claimant. The sums for severance package, constructive dismissal, and damages are hereby declined. The sum of 200,000 naira is awarded in favor of the claimant against the defendant as cost. The judgment sum shall attract 10% interest until it's fully liquidated.
We thank my Lord for a well-considered judgment, my Lord. Thank you very much.
Thank you. Thank you.
Thank you.
I forgot this. My Lord, we are very grateful for the well-considered judgment. And I pray that the Almighty God continues to strengthen my Lordship and give my Lord good health and iman to continue to act properly.
So it's win-win, ba?
It's a win-win, my Lord. My Lord, that's why it's a win-win. My friend who is not a lawyer was asking me this morning. I told him there's nothing like I won my case and I lost my case. The ability to strike a balance between parties that really matters. My Lord, I'm very grateful for the considered.
Thank you.
My Lord, and I hope that my learned senior, Olashade Ali, will not will advise our client to pay us immediately so that we can have something for the year.
Yes. Yes, for Olashade.
My Lord, I'm so sorry.
There's no money in the country, my Lord.
We are not taking cash. We are not taking cash.
The interest will be
accrued. We have problems with them, even transfer this.
There is interest that will be accrued,
Yes, it's from today, sir.
Yes, from today.
We'll ensure we do the needful, my Lord.
Okay, thank you.
My Lord, I also want to use the opportunity to thank my learned colleagues, Mr. Folashade Ali and Mr. Umar Saka. It's been a good relationship since this matter started. In fact, Mr. Umar calls me at times in the midnight to say, how far this our case? Have you gotten the link? And we share that.
We would like to say the same, my Lord, on record that Barrister Yusuf has been phenomenal. It's good for colleagues to work as it, and not think that everything is war. So we're representing clients and we do the needful to ensure that justice is done. So thank you, my Lord.
Thank you.
I also need to thank Mr. Folashade again. She bought me lunch one of the matters, one of the days we came to court.
One of the matters?
One of the days we came to court, she bought me lunch. She gave me money for lunch, and I really accepted it in good faith. I don't think my client
it's okay.
Yes, my Lord.
Okay, it's okay. Thank you so much.
Thank you, my Lord. Thank you very much.
Bye.
Thank you, my Lord. Thank you.
Thank you.
Okay, thank you.
Thank you.
Aja,
thank you, man.
Yes, my Lord. Yes, it remains only the motion.
The last case, yes.
Suit number NICS/LA/48M/2022 between MRS Holdings Limited and Mr. Christopher Okechukwu Okori.
Yes.
Wait, please, my Lord. Akurede Adelupe, my Lord. I appear for the judgment creditors / respondents, my Lord.
Akorede.
Yes, REDE, my Lord.
Adelupe.
Yes, my Lord.
Adelupe, yes.
For the claimant? Okay, for the
judgment creditors respondents.
My Lord.
Okay. Yes. Chukudi.
Sir, my Lord, respectfully, my Lord.
Yes.
Nina Chukudi.
Okay.
My appearance is for the judgment debtor / applicant.
Okay. Yes, Chukudi. Yes.
My Lord, I've spoken with my principal and I've gotten permission from him. So we're actually going to be withdrawing our application.
Thank you.
My Lord.
Matter is for hearing of our application, but we wish to apply to withdraw Mr. Adelupe. Any objection?
None, my Lord, none.
And you're not asking for costs?
Well, my Lord, we are told. I said we are told we're in our respective offices, and
okay.
We have not, due to my Lord's magnanimity, we have not spent any money on transport. We will not be asking for costs.
Okay, thank you so much.
You're welcome, my Lord.
Data. Me, I'm asking for my data from her.
We'll settle outside, but
that's not allowed. That's not allowed, Aja.
Okay, my Lord.
The government you know, is taking care of you so well, isn't it? Eh?
Yes. They are paying our salary. But they are not paying us for data, my lord. We are not giving that.
Allowances. Okay. So, in view of the application of the Learned Council for the judgment date to withdraw this suit is accordingly struck out with no order as to cost.
As the court
pleases.
As the court pleases.
So, Ajay, is that all? Ajay?
That's all for the day, my lord.
Okay,
Yes, my lord.
Thank you, Ajay. Chukudi and then Adelupe.
Yes, my lord. We wish my lord a pleasant weekend.
Thank you so much.
Yeah.
That will be all for today, and I wish you a very nice weekend.
Same to you, my lord. Most grateful.
So, bye for now. Thank you.
That's the court.
Thank you. Ajay, good night.
Good night, my lord. Thanks.
Thank you.